Mr. Albanese and Mr. Chris Minns. I'm here presenting some extremely serious issues that I have uncovered over the past 5 years in the Supreme Court of New South Wales and the Supreme Court of Appeal, New South Wales. Unfortunately, I've been before the courts as a self-represented party for over a decade now. For the first 5 years, I was fortunate enough to have Justice Paul Brereton presiding over my matters. As the government would be aware, Justice Brereton is the Commissioner of the National Anti-Corruption Commission. In my experience, Justice Brereton was the epitome of what a judge should be in acting impartially and independently when applying the law. Owing to that experience, I developed great trust and confidence in the Supreme Court of New South Wales and the judicial system of the Supreme Court. However, over the past 5 years, in civil proceedings I've been involved with, I have uncovered what respectfully highlights a very serious and systemic issue, in my view, in the Supreme Court and the Supreme Court of Appeal, New South Wales. The allegations I make are not made lightly. They're supported by volumes of documentary evidence. The first file of documentary evidence has been submitted to your chambers and to Mr. Minns's chambers for your respectful consideration. In my view, the evidence itself concludes urgent intervention and reform is required in the public's interest. Along with the video publications on this website, I've requested an open interview with Justice Beach Jones concerning the serious allegations I make against him and his misconduct I allege in the Supreme Court of New South Wales as the Chief Judge of Common Law Division. Justice Beach Jones is now presiding in the High Court of New South Wales. My interview request with Justice Beach Jones certainly, in my view, was in the public's interest. However, he declined that request. In relation to Justice Harrison, on 2 July 2024, I requested he intervene. I provided a publication that was detailed, demonstrating, in my view, irrefutable corrupt conduct that was occurring under his management as the Chief Judge. He refused to intervene. The ramifications I suffered from that refusal were catastrophic. In relation to Registrar Karen Jones, who was then presiding as a registrar in the Supreme Court of New South Wales and the Supreme Court of Appeal New South Wales, I detailed serious concerns, serious allegations, an open interview, a right of reply. However, she refused that request. In relation to Justice Bell and the Judicial Commission of New South Wales, he's failed to respond, failed to accept my invitation for an open interview, notwithstanding I provided detailed evidence confirming, in my view, irrefutably, corrupt conduct is occurring in the Supreme Courts of New South Wales. To be clear on my allegations towards the Judicial Commission of New South Wales, Justice Bell, who is the Chief Justice of the Supreme Courts New South Wales, he's also the President of the Judicial Commission New South Wales, I allege he has actively and knowingly allowed corrupt conduct to ensue in those courts. In addition, I allege Justice Julie Ward, who is the President of the Supreme Court of Appeal New South Wales and a long-standing member of the Judicial Commission of New South Wales, has also allowed corrupt conduct to ensue, has herself engaged in corrupt conduct. These allegations, obviously serious, I say conclusively supported by the first file of evidence submitted to the Parliament for your respectful review. In my view, also self-conclude, the Supreme Courts of New South Wales are acting like a kangaroo court. However, it's much more serious than that. I allege the documentary evidence self-concludes there is no duty of care when it comes to mental health in the Supreme Court of New South Wales. Judicial officers, in my view, are breaching their judicial oath ad nauseum. In addition, The evidence, in my view, self-concludes the conduct described rolls through to different departments in the Supreme Courts of New South Wales. Judicial officers are appointed by Parliament. They're given extreme power to administer justice independently and impartially. Obviously, coming with that power is the ability to cause serious harm to society if that power is misused or abused. As I've outlined briefly, in my view, the evidence self-concludes the powers are being abused and real harm is being caused to Australian citizens before the Supreme Courts of New South Wales, which is completely untenable and needs to be addressed. Dozens and dozens of litigants have come forward, largely self-represented persons before the Supreme Courts of New South Wales, with the same stories. A few examples of what's occurring and what the evidence supports include judicial officers conducting court hearings unbeknown to certain parties in those proceedings. Judicial officers making cost orders, adverse cost orders, against self-represented parties after they've left the courtroom. Extremely serious. Judicial officers asserting they've made cost orders favourable to the self-represented party. However, those court orders never get made. Again, extremely serious. Wrongfully dismissing proceedings for want of due dispatch. Judicial officers allowing proceedings to run and making millions of dollars in adverse judgments against persons who are plainly under legal incapacity. This is completely illegal when it comes to the law under section UCPR 7.13 and also under UCPR 7.17. Those proceedings cannot continue unless a litigant has a tutor or a litigation guardian appointed. In addition, the evidence suggests judicial officers in the Supreme Court of New South Wales are actively and knowingly causing mental health harm upon self-represented persons before the courts to ensure an outcome sought by the court can occur. Again, an extremely serious allegation I don't make lightly. And what's even more concerning is the Judicial Commission of New South Wales, which is the body who governs corrupt conduct over judicial officers in the Supreme Courts of New South Wales state sector, in my view, are actively and knowingly burying or covering up extremely serious complaints about judicial officers. The Judicial Officers Act 1986, which is the legislation that body applies, respectfully, in my view, and many professionals around me who have been involved in collating the information and documents to submit to Parliament, self-conclude that legislation is riddled with issues that covers up corruption, in my view, that allows corrupt conduct to continue, in my view, and needs urgent reform to safeguard the lives of Australian citizens, in my respectful yet firm opinion. You Be the Judge has evidence of past and present members of the Judicial Commission New South Wales who are responsible for overseeing corrupt conduct, have allowed corrupt conduct to ensue, have engaged themselves in corrupt conduct, in turn have breached their judicial oaths ad nauseum. Again, I don't make that allegation lightly. In short summary, the Judicial Commission of New South Wales and the Judicial Officers Act 1986, in my respectful opinion, is a complete ruse. The body is set up, in my view, to cover very serious misconduct that is occurring in the Supreme Courts of New South Wales ad nauseum. Since inception of the Judicial Commission, they've been granted over $130 million of taxpayers' money to administer and oversee corruption. Respectfully, that's not been upheld. This funding is allocated notwithstanding the serious cost of living crisis before Australian citizens. One only needs to look at the legislation and the law in relation to suspending or standing down a judge or registrar or judicial officer for alleged misconduct. The Judicial Commission of New South Wales is responsible for taking steps to suspend or stand down a judicial officer or judge who has engaged in serious judicial misconduct. As I've outlined, the concerns with that body, past and present members, is extremely concerning and, in my view, needs urgent intervention. On 6 December 2021, the Australian Law Reform Commission submitted a document to Parliament, an extensive document, some 1,616 pages. The document, among other things, proposed a judicial commission be set up to administer the jurisdiction in the federal and Commonwealth sector for judicial officers acting in those courts. With all due respect, if that commission in any way resembles the Judicial Commission of New South Wales and the Judicial Officers Act 1986, which plainly needs to come under the spotlight, it would be disastrous, in my opinion, to Australian citizens seeking justice in those courts. In addition to the law under the Judicial Officers Act 1986, making it near impossible to have a judicial officer stood down or reprimanded or removed from the bench for serious misconduct, the legislation under the Constitution Act, Section 72, also makes that process extremely difficult. Upon review of the documents submitted to Parliament, to Mr Albanese and to Mr Chris Minns, the only conclusion, in my view, that can come from that is the current judicial system in the Supreme Court state sector, New South Wales, is a national disgrace. If the Albanese government agrees with my allegations, more importantly, if they agree with the volumes of corroborating evidence supporting those allegations that have been submitted to Parliament, the only resolution, in my view, is prompt, swift action. That would include a bill put forward in Parliament immediately for a review of the law concerning the Judicial Officers Act 1986, in addition, the Constitution Act in relation to removing or suspending judges for serious misconduct. In my view, the only course can be immediate suspension of the offending judges in the Supreme Courts of New South Wales and the Judicial Commission of New South Wales. Urgent reform and investigation must occur in the public's interest. I look forward to the response from Parliament in relation to tackling these extremely serious public interest issues. Thank you.